Welcome to the Pacific Research Institute's Next Round podcast. I'm Rowena Itchon, COO, and with me, as always, is Tim Anaya, Vice President of Marketing and Communications. So we're going to get right into the podcast today because it's a bit longer than usual. Our guest this week is Erik Jaffe, and Erik is a partner at the Washington law firm of Schaerr-Jaffe and a former law clerk to Justice Clarence Thomas. Erik is a PRI legal scholar, authoring many of our amicus briefs. I always look forward to our podcast every year with Erik, Tim, on the Supreme Court decisions. He's great about peeling away the complex legal issues and explaining what's at stake. And he really knows the court and follows their opinions, and he can give us a really great insight on the major decisions.
That's right. I look forward to this podcast too, because you may not realize it, but there are so many key issues that really do affect our daily lives that the Supreme Court is ruling on every session. You hear the key ones that make all the news, but there are a lot of others that don't get the news coverage that they should. And, our chat with Erik every year really gives some needed perspective on those cases.
So, Tim, I'm really interested in the Grants Pass case. And as some people know, that we filed an amicus brief for the Grants Pass case. And that's a case that restricted a town in Oregon from clearing the homeless from their streets. And it was because it was argued that it was cruel and unusual punishment. So Erik wrote our brief, and I'm looking forward to the court's decision.
Now, I'm interested in one that hasn't gotten the media attention that it should, but certainly is a very important case. And that one, and it involves taxation, so people's eyes might be glazing over already, but the case is Moore versus the United States. And the crux of the case is that there was a couple that had to pay taxes on an investment that they didn't profit from. And so what the case is really about is it's kind of a backdoor approach to having a wealth tax. And of course, that's a key issue before Congress, and even states like California have mulled implementing wealth tax legislation. And so there are a lot of interesting constitutional issues in there. And Erik, as we mentioned, filed our amicus brief in that case as well. So I think that will be really interesting to see where the court comes down on a hot issue before Congress and many state legislatures.
Well, just a quick note before we go on into the interview, I wanted to remind our listeners that we've got a great event coming up. On June 25th, we'll be hosting Victor Davis Hanson in Napa Valley at the Meritage Resort. So many people know that VDH, as we like to call him, is a military historian, a classics professor, and he's going to talk about the threats to America here, domestic and foreign. We've also got another special guest that afternoon, Fritz Maytag, owner of York Creek Vineyards, and he's going to discuss water, wildfires, and wine in the valley. So it's going to be a wonderful evening, and we hope to see you all there. And now here's Erik Jaffe in conversation with Lance Izumi, who few people don't know that Lance is actually a trained attorney. Thanks so much, everyone, for listening.
Well, thanks very much, Erik, for joining us on today's podcast. Let's start off with the case that everybody is waiting for, Donald Trump versus United States. The Supreme Court is set to decide whether presidents are immune from prosecution for supposed acts committed while in office. The Supreme Court's review is in response to ongoing federal prosecution of Donald Trump for allegedly interfering in the 2020 election while still in office, including events leading up to January 6th. Now, what do you think the court will decide on this issue?
Well, thank you for having me, first of all. I always enjoy being on this show and working with PRI and talking about these cases, and this is no exception. Full disclosure, I had a brief in the Trump case on arguing against immunity on behalf of a couple of law professors, and my law firm actually had two other briefs arguing issues tangential to the immunity question, but nominally in support of Trump. So we're in an interesting position, just for whatever that's worth for the listeners who might take my words with that understanding. But I think the court will deny the absolute immunity being claimed by President Trump. I'm almost certain they will deny the sort of the more far-reaching claims that he and his attorneys have made. And they will set a standard that provides some instances of immunity, but probably far less than they are hoping for. So during the argument, for example, there was a lot of discussion about what constitute official acts and what constitute sort of the private acts of candidate Trump. And even President Trump's lawyer acknowledged that for certain acts, those would be private acts and not official acts. So his dealings with private attorneys rather than government attorneys, for example, would not be immunized. And I think that there's a real question, that the court is struggling with a real question about when do even nominally official acts sort of lose their official flavor. So you could imagine situations where a candidate is misusing government resources for their own benefit. And we have these situations all the time in our campaign finance and campaigning rules about when you can use government resources to campaign. So for example, when the president goes on a campaign trip to obviously it's for his campaign, it's a private act, not a government act, but he still has government security because he still remains the president of the United States. And so these are lines that we draw in lots of circumstances. And I think the court will struggle on where to draw a line between when are you engaged in an actual official act and when are you engaged in a misuse of official resources or official position for personal endeavors. And you see that over and over again in the examples they give. What if you order, the military to try to kill your opponent? What if you do things like that? And I think you also see it even in Justice Alito's questions about perhaps there are some extreme circumstances where you so abuse your official position for personal gain that we wouldn't give you immunity. And that's what where the rubber will hit the road, is where they draw that line. My guess is that it may be something akin to Justice Alito's line, which says, for most official acts taken in an effort to engage in official presidential behavior, there will be immunity. But there will be a subset of egregious acts where you really lose that immunity. So think of it as almost a qualified immunity situation. And it's just a question of what are the qualifications of that immunity? I think it may be slightly broader than the qualifications you see in the sort of police circumstances, qualified immunity, but it's hard to say. But I think at the end of the day, what will happen is this case will continue. There will be a triable issue regarding his non-official acts, which even his lawyers concede, but there will be further proceedings to try to parse which allegations in the complaint involve official acts and which do not. The last thing I'd say is that I think there will be a debate about whether even immune official acts can be used as evidence in support of criminal charges based on non-official acts. Trump's counsel suggested that not merely could you not bring a charge based on, for example, his conversations with the DOJ, which he would categorize as an official act, but that you couldn't even bring those actions into evidence, even in connection with charges dealing with non-official acts, such as conversations with private attorneys. And I think that's an interesting question. I don't know how that will come out. My guess is that they will say even official acts can serve an evidentiary purpose, but may not be grounds for a criminal charge themselves. Personally, I think that answer will ultimately be wrong. I don't think a president is immune, even for their official acts, absent congressional legislation providing such immunity. I kind of think that, and what I wrote in my brief, is that violation of federal criminal law, as distinguished from state criminal law, violation of federal criminal law violates the president's duties to faithfully execute the law. And hence that can't possibly be immunized. I don't actually think the court will agree with me, but I think that's the right answer. I think that's the textualist answer. And I think that all the other efforts to provide immunity are driven by policy considerations, which I think you saw in the oral argument, that there was tons of, what if. And while that's an interesting argument for sort of the old way of adjudicating cases in like the Warren court, perhaps, it's a little shocking hearing those kinds of arguments coming out of the Roberts court and the vestiges of the Rehnquist court for folks who seem to be loath to take up judicial policymaking. Yet there you have it. I think that's what will happen. And I think we'll get at least some immunity. And the question is how broad that will be.
Just out of curiosity, do you think that the court will split along the conservative liberal boundary there? Or do you think it would be kind of a different makeup of the majority decision?
I think there will be unanimous support for some level of immunity. I think they will split on where they draw the line. And so obviously I sort of feel like the conservatives may well draw the line in a way that allows for more immunity, and the liberals will argue for less immunity. And it's hard to sort of know where. And I think Robertson, Barrett, and probably Kavanaugh will come out somewhere in the middle. So it's just a question of which version of immunity gets 5, basically. And I'm not sure which version, what level of internal negotiations will happen as to sort of exactly where to draw that line. But I think you will see less immunity inclinations, and I think you'll see lots of concurring opinions arguing about where that line ought to be while sending it back to the lower courts to sort of at least trim off some of the potential charges.
Let's jump to a totally different subject. There are 2 tech cases that are especially important here in California. In Moody versus NetChoice and NetChoice versus Paxton, Florida and Texas regulations on social media are being challenged by a group of tech companies. The Florida law imposed fines on companies such as Twitter, X, Facebook, and YouTube for banning or otherwise censoring political candidates, while the Texas law lets citizens or the state's attorney general sue those platforms for removing political content from their websites. The tech organizations, NetChoice and the Computer and Communications Industry Association, argue that the tech companies have a right to decide what content is permissible on their platforms under the First Amendment. The tech advocates say that they operate more like newspapers and they can exercise editorial judgment. But the states are saying that the social media functions are more like the public square, and when tech companies are exercising control, what they are in effect doing is actually limiting speech. So how do you think this case will be decided?
Once again, a disclaimer up front. I have a brief in this case for Reason Foundation, the Committee for Justice, and the National Taxpayers Alliance, arguing in favor of the tech companies. My view about what should happen and what will happen, hopefully the 2 are the same, what I believe ought to happen and what will happen, though I'm more confident about my normative views than I am about my predictive views. So the issue here, as you pointed out, is whether social media platforms like Twitter or X today, X or Facebook, are mere conduits for other people's speech, exclusively conduits, versus editors who are sort of bringing together other people's speech, but with a macro vision of some sort in mind. I would also point out that there's these cases reflect a little bit of new and growing skepticism on the right about corporate speech rights in general, something that most sort of conservative lawyers and judges had pretty solidly supported back in the day. Think of Citizens United, First National Bank of Boston versus Bellotti, Miami Herald, and sort of other cases dealing with associational speech like the Boy Scouts v. Dale. And now, of course, there's a lot of hostility to that as conservatives view corporations as against their political interests. But in any event, I think at the end of the day, Texas will lose and Florida will mostly lose, or at least live to fight another day, but eventually lose. And the reason I think that is several. First of all, I think the argument that Facebook and companies of that ilk are mere common carriers like a telephone company or like a railroad is not going to win the day. I don't think it's correct. I think it's actually slightly absurd. And I don't think it will win the day. It may pick up a vote or 2 from Thomas and Alito, but I don't think you're going to see 5, certainly. I think the rest of them will concede that those entities engage in editorial functions not unlike many other sort of aggregators of speech, such as newspapers or magazines, which aggregate speech, or such as parades, which aggregate lots of speakers under a macro banner and reserve editorial rights. Those precedents strike me as both correct and largely indistinguishable. The notion that some private entity on the internet is now the town square in the same way that a company town where you had no other choices suddenly becomes governmental in nature, I personally think that's embarrassing. I think it's embarrassing for people to make that argument, particularly upon a time exactly the opposite of that in cases like the Boy Scouts, in cases like Red Lion, in cases like Citizens United. It's just embarrassing. So as you can tell, I feel rather strongly about this, and I don't think it's going to get a majority support precisely because those earlier precedents are fairly obviously more analogous to this than, say, the telephone company kinds of precedents, or the cable, even cable companies, right? Once upon a time, we said this about cable companies, and conservatives mocked those cases as ridiculous, both factually and legally. And I think the earlier mocking of those cases was correct, and the current willingness to go to the other side is just opportunistic. So I think Texas goes down because it's pretty clear that they're trying to control the speech and particularly the associational rights of media companies that are trying to form sort of an expressive association that says, we invite people to come and join our conversations and join this salon, this virtual salon of sorts, a very big virtual salon. But here's the folks who are not welcome. And we wouldn't think anything of that if this were, the Lions Club or any other private association that said XYZ folks are welcome, all are welcome, except there are rules. And if you break our rules, get out. We would think that that's free association. The fact that conservatives now call that censorship, I think, is just a category error. They think that the right not to speak and the right not to associate is somehow equivalent to governmental censorship. And of course, it's not. Private rights to choose who they associate with are protected. And others are not. The Florida law, by contrast, raises some interesting problems because it applies to far more than just media companies. It applies to, all other sort of internet-based companies like Uber and Gmail and Etsy, and folks who might not fairly be categorized as expressive or primarily expressive in nature, but in fact, indeed, as providing some non-expressive service like Uber, where, discriminating against people based on their viewpoint, we probably could restrict those folks. They're not engaged in speech, they're not engaged in editorial, they're just discriminating based on viewpoint. And while I think that in a purist free association world that might be defensible, the current jurisprudence doesn't agree with me on this. And so when you're not a speech association of some sort or a speaker of some sort, those things probably don't win the day. Florida also has a problem with the scope of the injunction. Given that there are potentially valid applications of the Florida law, even though it can't apply, I don't think will be able to apply to media companies. The injunction itself may be overbroad, and a facial challenge may be too much. It may need to be a more targeted challenge to just its application to media companies. So while I think Texas will lose because it is applied primarily to media companies, Florida will effectively lose in the sense that they won't be able to apply it to the people they really want to apply it to, but perhaps they'll lose smaller and still be allowed to apply it to sort of non-expressive entities. I imagine Justice Thomas and Justice Alito will dissent from what I predict to be the results and say that, of course, you can regulate media companies because there's no right to censor. Again, like I said, I think that's a category error. What will be interesting is to sort of see where folks like Justice Gorsuch and Justice Barrett go on this, and whether they simply join, sort of a centrist opinion, or whether they write separately to provide some more nuance to their views. I think that will be a very interesting piece of this.
Really interesting to see how the court breaks on this one. The next case we want to talk about sounds a lot more esoteric. But depending on the Supreme Court's decision, the case could significantly impact the power of the federal government to regulate our lives. In Loper Bright Enterprises versus Raimondo, It involves a group of commercial fishermen who sued the National Marine Fisheries Service over a rule that requires fishermen to allow federal observers to monitor overfishing on board their vessels. In addition, the fisheries are required to pay the salaries of those observers. The group is challenging a 1976 law that granted the federal agency the authority to engage in such monitoring. A ruling in the group's favor could essentially do away with the principle of Chevron deference and dismantle many federal regulations. How do you think this case will be decided?
Once again, disclaimer: my firm has a couple briefs in that case, in the Loper Bright case, in support of the challengers, and against Chevron deference. So take that for what it's worth. But I think the court is likely to dump Chevron deference in most situations. If they leave any of it intact, it will be in extremely narrow situations that rely heavily on some kind of technical expertise that the court will say warrants at least some modicum of deference. Though I think there are better ways of getting at that, and the court may well choose those better ways that don't involve deference per se, but just involve giving due consideration to the expertise of an agency on subjects that the agency actually has expertise on. But I will say that the general Chevron doctrine, I think, is ready to be interred and buried and cremated and all of that good stuff, because it's a process the court has started years ago in terms of narrowing the application of the Chevron deference doctrine and cutting back on it in situations where we don't want agencies taking up the mantle of policymaking by the mere implied delegation of Congress having written a vague and crummy law. There's an interesting separate question about what happens when Congress expressly delegates a degree of policymaking to the agency. But Chevron, at the end of the day, basically said, well, if we're not 100% certain about what the law means, or 90% certain that this is what the law means, if we can find some ambiguity, we'll give agencies free rein to sort of make policy choices within the scope of that ambiguity. And I think the courts have been backing away from that notion over the years because they're becoming more and more skeptical of such an implied delegation of legislative power, basically, to administrative agencies. And this is the non-delegation doctrine coming back into vogue. And I think that's entirely right, by the way. I think that's exactly what should be happening. So I fully agree with the court's movement in this direction. But what I think you'll see is a lot of criticism of this notion of implied delegation, a lot of criticism of the notion that agencies can supplant the courts when it comes to saying what the law is, as opposed to what it ought to be, and that they don't get as much deference there. I think you'll see some separation of powers arguments there. It'll be curious to see if they leave even a sliver of deference intact. Like I said, I think they would be better served by simply pointing out to courts that, of course, when you have an expert agency on expert technical or scientific issues, you should be attentive to such expertise. But that's different. Attentiveness is different than deference, particularly when it comes to the meaning of words. Agencies can inform, but I don't think they get to dictate. And I think that's exactly what the court will say. One interesting point, I think, when they talk about ambiguity and how courts resolve ambiguity and whether ambiguity justifies letting agencies have a little more leeway, there's some spillover consequences to that kind of conversation in things like the rule of lenity, for example, which applies in criminal law cases where if a statute's ambiguous, you tend to interpret it in favor of the defendant, not in favor of the government. There's spillover in doctrines such as void for vagueness, where if a statute is sufficiently ambiguous, it might be deemed too vague for enforcement, again, particularly in the criminal law context. And there's a case up at the court now, Cargill, which deals with such issues in the context of bump stocks. So I'm looking to see what the overlap between Cargill and the Chevron stuff is, because I think the question of statutory ambiguity is quite interesting. But at the end of the day, I expect 6-3. Chevron gets, if not fully chopped up and diced up and buried, certainly 95 to 99% diced up and buried.
That would be a sea change if that happens. So, that's very interesting. So,
Well, let me say it will be a doctrinal sea change, but as a practical matter, we're halfway there already. The court has adopted a whole bunch of doctrines limiting the degree of deference, emphasizing that courts should use every available tool of statutory construction before they decide whether a statute is ambiguous, adopting the major questions doctrine, which says that where there are important policy issues to be had, Chevron doesn't apply. So yes, there will be sort of a nominal sea change, but the reality is Chevron hasn't won at the Supreme Court. They've been ducking it because they don't really agree with it. It may be a sea change in the lower courts, however, who no longer can defer to agencies.
Let's go to a case where PRI has filed an amicus brief. The Supreme Court will decide how far vagrancy laws can go to restrict homelessness. In Grants Pass versus Johnson, an ordinance in Grants Pass, Oregon, prevented homeless people from sleeping and camping outside. The law was challenged as cruel and unusual punishment under the Eighth Amendment. The case will have major ramifications on how far cities across the country can go to clear homeless people from streets and other public spaces. You filed our brief, Erik, arguing that the framers of the U.S. Constitution would never have considered vagrancy laws as cruel and unusual punishment. Could you give us a little more background on how you think this case will be decided? And, it's especially important for California, which has a huge homeless problem.
Absolutely. I think at the end of the day, Grants Pass will win on the issues it has raised. Whether that win translates into a sort of complete win in the lower courts is a separate question. So the very narrow issue that was taken up to the Supreme Court is, like you mentioned, whether or not putting people in, finding them and putting them in jail for camping when they're involuntarily homeless. This is the Ninth Circuit phrase, involuntary homelessness, whether that constitutes cruel and unusual punishment. What it did not ask and what it did not address is whether fining people who sort of have no choice but to sleep outside is an excessive fine, for example. That was expressly carved out from the questions raised before the Supreme Court. And more importantly, whether or not putting people in jail for involuntary homelessness would constitute disproportional punishment. Again, expressly ducked on the question presented by the party briefing, and the Ninth Circuit actually didn't reach that question. So all we have is this notion of whether putting people in jail for involuntary stuff is cruel and unusual in the general sense. And Grants Pass had argued that the cruel and unusual clause applies to the nature of punishment, not to the crimes for which punishment is applied. And that is a very tiny, tiny portion of the Eighth Amendment debate. What I think is really going on here is not whether or not jail per se, short jail sentences per se, are cruel and unusual in the abstract, but whether applying jail time and fines, the things that people can't control, is disproportional punishment. Or improper punishment disproportional, because if you can't control it, why in the world are we punishing it? So think of things like insanity defenses. Think of things like somebody, you didn't know that you were committing a crime because somebody slipped some drugs into your bag and you're not the one who put them there. These are sort of mens rea kinds of questions. Occasionally there are sort of justification or necessity defenses where, yes, I crossed the yellow line, but I did it so I didn't run over a baby carriage. That's a necessity defense. I had to break the law because the alternative was worse. These are all questions of proportionality and whether or not it would be improper to do that. And no one has suggested that there's no proportionality doctrine within the Eighth Amendment. And so I think what the court decides here will certainly be that it's not cruel and unusual punishment to put people in jail for loitering and camping and whatnot, but they will leave open potentially how one deals with these notions of voluntary or involuntary behavior and who gets to decide. What I think the correct answer is, and what we argued in our brief, the PRI's brief to the court, is that these kinds of questions about, volitional acts, necessity, whether you have no choice but to camp out because you don't have a place to go, these are dealt with by all kinds of state law doctrines, including, as I mentioned, the necessity defense and mens rea defenses and things like that, and justification defenses. And I think the court will likely agree with that. and say that indeed there are many state law bases for a defense against the charge of camping, that say I had no choice, I had nowhere else to go, and that they will, in the first instance, let state courts deal with these kinds of issues. And eventually they may be forced to decide that state law doctrines are not adequate to deal with such things or are too narrow to deal with legitimate involuntary behavior defenses. But I don't think they're going to do that here. I think they'll leave that for another day. They'll note that the court below was wrong, that it should have done this on, allowed states to litigate these things on a case-by-case basis and defendants to litigate these things on a case-by-case defense for their actions. But they're not going to constitutionalize, in the first instance, state efforts to deal with what is admittedly a very thorny problem of homelessness and of people who are legitimately without meaningful other choices, but some of which who may have other choices that are perhaps not appealing, but are still available as choices. It's a very hard question. It's very hard to know where to draw the lines. And I can't imagine that the Supreme Court wants federal courts drawing those lines in the first instance, as seems to be happening in California right now. So the good news for localities is that they will be given more leeway to sort of experiment with different ways of dealing with this problem, and not only sort of saying you can't camp on certain parts of our property, you can't camp in the park, but dealing with better ways of addressing sort of perpetual homelessness of folks who may be suffering mental illness, of drugs, or other reasons that make it very hard for them to get out of their situation. But that states obviously have an interest in trying to fix, but are not going to be willing to let encampments, for example, take over city parks or city streets.
Well, that's really interesting because given the fact how important an issue homelessness here again is in California, I think we're all going to be really watching to see what happens at the Supreme Court on that case. Let's take a look at a case that's already been decided, but which I think is interesting to talk about still. It's the case of racial gerrymandering in South Carolina. The Supreme Court reversed the district court's decision, holding that it clearly erred in its finding that race was the predominant factor in the redrawing of a South Carolina congressional district. The court ruled that the district court had not met the appropriate standard for identifying racial gerrymandering. Now, given the close correlation between race and party affiliation in South Carolina, the court argued the proportion of Black voters in the redrawn district could have been merely a consequence of partisan gerrymandering rather than an overt goal of the redistricting plan. Why is this case important, and what are your thoughts on it, Erik?
This is one of the few cases that we don't have a brief in. So, I think it's important because it once again continues a trend of trying to move the courts out of dealing with thorny political issues that they're really not equipped to draw coherent, defensible lines. That many of these issues are sort of multifactorial, balance this, balance that, what's going on here, what's going on, they have so many moving parts that at the end of the day, they really are political questions in a strong sense that courts just can't fix without making political choices of their own. Indeed, Justice Thomas, in his partial concurrence and partial dissent, sort of goes through and says exactly that constitutionalizing these issues without any kind of clear constitutional standard is just inappropriate for federal courts. And I kind of agree with them that it is. If you're just asking courts to make up their own judgment on these things, you don't really have law in the traditional sense. What you have is judicial policymaking. Now, I think it's interesting for a few reasons beyond that. First of all, it impacts lots of other cases. These two arguments were strictly constitutional claims. The gerrymandering claim was a constitutional equal protection claim, and the vote dilution claim was a constitutional equal protection claim, voting rights kind of claim. It doesn't deal with statutory claims, for example, under the Voting Rights Act. Though that being said, a lot of the arguments being made here certainly have carryover or knock-on effects when you do get to the statutory arguments. And I think that is sort of inevitably going to be part of the argument landscape going forward, even on statutory cases. So the court, for example, was much more aggressive at looking at facts and expert opinions and getting into the weeds on that than I think we've really seen in a lot of instances. And it's a sort of an interesting and surprising thing coming from conservative justices. And indeed, Justice Thomas, the part of the opinion he did not sign on to was exactly that. He thought it was inappropriate for the court to get that deep in the weeds on the facts and on inferences and on fighting about experts. He would have taken a much more categorical approach to this and said, look, given that political gerrymandering is okay, or certainly is not something that courts can police, that it's very hard to figure out where, absent direct smoking gun evidence, that racial gerrymandering is going on if there is indeed a high correlation between politics and race, which I think much of our past voting rights jurisprudence has largely assumed. Rightly or wrongly, it has assumed that there is a high correlation between politics and race. And while it's okay to discriminate on politics, it's not okay to discriminate on race. And yet, if you discriminate on politics, it will obviously have a racial impact, if not a racial intent. I think it's fair to say that Republicans would be very happy to bring in Black conservatives into their voting districts, that they don't actually care what the color of your skin is. They care which way you vote. And so I think it's fair to say that yes, the political discrimination is not ipso facto equivalent to racial discrimination, which is the point Justice Thomas makes. So that's the, I think we'll see more of that. I think we'll see more skepticism of sort of mere effects of correlation being used to demonstrate racial discrimination when indeed it could just be an instance of political discrimination. And that will indeed carry over even to the statutory cases, not just the constitutional cases. Indeed, I have a number of cases in defense of the state of Georgia for their voting laws, where things like the presumption of good faith and the legitimacy of political decision-making will play a big role in those cases as well, even though many of those cases are statutory cases. So the takeaway, I think, for the gerrymandering cases is it's going to be much harder, if not close to impossible, to prove a racial gerrymander without serious smoking gun evidence, where somebody says, get race X out of my district, and the map drawer says, okay, we'll do. And that, unless you're a complete idiot, no one's going to put that evidence in. So what we're going to have is it's going to be very hard to prove these cases. Perhaps a few hidden intentional discrimination cases will slip through. But in most instances, you might well be dealing mostly with political discrimination and not racial discrimination. The last thing I would mention about these cases is that at the end of the day, there was a little vote dilution claim that sort of got all of a paragraph or two of attention in these cases that they also kicked out. And Justice Thomas gives some more attention to those cases, reiterating his longstanding dislike for vote dilution cases, because again, there's no objective criteria for when is a particular group's vote diluted, and it forces you to make racial group judgments about what candidate a racial group would like rather than individual judgments. It seems to be the antithesis of a race-blind constitutional analysis. I've always thought Justice Thomas was right on those things. Once again, this makes it harder to prove those claims. I don't think the court is anytime soon going to take up Justice Thomas's fuller view that vote dilution claims are illegitimate on their face as being standardless and subjective, but it will at least be one more step in that direction. And I suppose that's all for the good. Vote dilution assumes a baseline of from what are you diluting the vote from? What's the baseline? What's the proper amount of influence minority group X or minority group Y ought to have? And how should that influence be wielded? These are questions that courts are notably terrible and unequipped to decide. And I think, like I said, Justice Thomas is dead right on that. And I think this decision will push us at least a little bit further down that path, if not all the way down that path.
Well, let's go from race to another hot button issue. In the overturning of Roe v. Wade, it opened the door to other abortion-related issues. The Supreme Court will decide whether to overturn a recent FDA guidelines for distributing a commonly used abortion pill by mail and telemedicine. The case will determine whether access to the drug, which is used in the majority of abortions in the United States, will be sharply curtailed. And the other case involves a federal law that requires emergency rooms to provide stabilizing care to all patients and overrides a state law in Idaho that imposes a near total ban on abortion. The decision may affect more than a dozen states that have passed near total bans on abortion. The state's ability to pass their own laws on abortion will likely mean abortion cases for years to come. And, obviously a lot of things for lawyers and the courts to deal with. What are your thoughts on this, Erik?
Well, once again, I'll start with a disclaimer. I generally don't touch abortion cases with a 10-foot pole if I can avoid it. My firm, however, does, and including filing briefs in both the FDA and the Idaho cases. I'm not on those briefs or involved in those cases, but it therefore somewhat constrains what I talk about in those cases. But I think the interesting parts of these cases, less than the sort of abortion-specific fights, are the broader issues related to things like preemption, standing, and the ability of states and individuals to challenge various actions by Congress and executive agencies where abortion is concerned. What was sort of so interesting and is so interesting in the evolution of abortion law these days to me is, once upon a time, sort of the anti-abortion crowd would point out that, there are all kinds of abortion exceptions to pretty standard doctrines, like standing and things like that. And that, somehow those doctrines never quite got applied in the same way when abortion was concerned, because, the court was, bent on protecting abortion and ignoring sort of these doctrines that stopped it from doing that. And now I think the shoe is on the other foot. Now that, folks want to challenge federal executive action and congressional action in different areas, all of the arguments made to sort of stop challengers before are being raised by the abortion opponents to stop challengers from the other side. It's a wonderful reversal of sort of what you think depends on where you sit and where other people sit. I think we should just enjoy the reversals and the uncertainties of all that while we're confronted with it. But that said, I think that on the standing issues, there are some serious standing problems in the I can't even pronounce the drug's name, the abortion pill case, where the doctors raising the challenge, their injuries are at best speculative, and I think the court is very likely to say as much and sort of dump the challenge based on lack of standing in those instances. Not to mention sort of the mismatch of remedy. The doctors who brought the challenge are primarily arguing that the reason this is terrible is because the pill occasionally leads to emergency room visits when it doesn't work in a percentage of cases, and they might be in the emergency room when that happens, and they might be forced to perform an abortion against their conscience when the pill didn't properly work. They might be forced to to finish the job, so to speak. And that chain of reasoning is spectacularly speculative, particularly given that there are federal protections for folks who have a conscience-based objection to being involved in abortions. And those objections are protected already under federal law and by most hospitals, by all hospitals, as far as I know. So I don't really think I think this case is very likely to get dumped on standing. And there you have it. Justice Alito was probably the main voice of skepticism about, if these doctors can't bring the challenge, who can, and the lack of a remedy if the FDA somehow did something wrong here. Again, I find that amusing, given that the absence of a remedy is usually, where there's a right, there's a remedy, is usually an argument made by people enforcing constitutional rights. And it's usually the conservative wing of the court saying, too bad, so sad, there's no standing. And if you don't like it, go to the political branches. It's ironic to see the shoe on the other foot here. I think there will be a dissent, or at least a partial dissent, or a separate judgment, separate concurrences at least, by Justice Alito and Justice Thomas, dealing with the so-called Comstock Act, which makes it illegal to mail abortifacients. Which is a federal law, and I think it's interesting. It wasn't the primary subject of briefing in this case, but you have to get past the standing question first. But I think you will at least see some commentary on that, if not an attempted, if not an actual statement that they would rule on the question. And so that will be interesting, not so much for this case, but on cases going forward. On the Idaho case, which deals with how one handles emergencies where a pregnant woman is in distress, is in danger of their health being compromised, and might need an abortion. That case, I think, is again sort of interesting, less for the details of the federal law that says you have to give emergency treatment where the health is at risk, versus the Idaho law, which says you can't perform an abortion in many cases, than it is for the more broad principles of federal preemption. We see this all the time, federal preemption of state laws in the context of FDA approval of certain drugs and of FDA approval of drug inserts, warning about the risks and the dangers of those drugs, versus state tort law, which let people injured by drugs bring suits for failure to properly disclose the risks. And invariably in those cases, there is federal preemption. Here, I think that the case for federal preemption is actually somewhat weaker than in many of those cases. You'll see that this is a law primarily designed to protect people who can't afford hospital treatment when they're in an emergency. It says you have to treat them notwithstanding being able to afford it, but the wording of the law is slightly broader than that. And it talks about you have to render the necessary treatment to preserve their health if they come in an emergency situation. And that, that raises an interesting question, but there's plenty of room here to sort of say that there's no real conflict between federal and state law, particularly given that Idaho has interpreted its state laws slightly more narrowly than you might imagine. And then its reading might suggest, saying that you can treat pregnant women and provide an abortion even where you're talking about the health of the mother, not merely the life of the mother. So I personally expect them to say there is no real conflict between those two laws, largely because Idaho would allow the kind of treatment that the federal law requires. So, I think they will basically say not much to see here. Federal law can still apply, Idaho law can still apply, and so it goes away, or at least a broad injunction goes away. That seems to me the most likely argument. I think there's an interesting side issue, by the way, of the spending power and whether or not Congress, via the spending power, can override state criminal law. That was an issue that got some discussion in oral argument. I think is very interesting. I think it also, in some sense, supports the notion that there's no preemption, no square preemption, that if it's a spending clause issue, Congress may be able to withhold funds, but it can't get an injunction stopping you from doing the behavior. It can only withhold funds. It can't force you to behave the way it wants you to behave. So once again, I think preemption is unlikely, but there may be a lot of interesting side commentary coming out of the decision on why preemption is unlikely. And what I would tell readers to look for is whether that side commentary is consistent with the court's earlier preemption cases and views in situations where it was much more hostile to the state law than perhaps some of the court members are here.
Let's go to just one last question and one more case. It's Moore versus the United States. And this is another case where PRI has filed an amicus brief, and it concerns a couple who had to pay taxes on an investment from which they didn't profit. So potentially calling a significant number of provisions in the tax code into question and thwarting a wealth tax on Americans, depending on how the court rules. So the case revisits our definition of income as outlined in the 16th Amendment, and whether individuals and companies must realize or receive profits before incurring taxes on unrealized gains. So what do you think the court will rule on this one?
I unfortunately think our side will not prevail in this case. I think the government will win. It will probably be a narrow win, upholding this and very similar taxing structures that deal with foreign corporations, and whether or not you can impute realized corporate income to the underlying shareholders, particularly where the shareholders have a substantial chunk of the shares. Arguably a controlling interest, even if not literally a controlling interest. And so I think they'll lose. The reason I think they'll lose is because there are too many cases out there and too many concessions dealing with what I would call imputed realization. Think of partnerships, which the partnership makes the money, but the income is imputed to the partners themselves, even though it's a separate legal entity of the partnership. Think of S corporations where this can happen. There are lots of other examples like that where income is imputed to an underlying shareholder, not to the top level corporate entity. And I think that they'll find that to be more than enough, that those exceptions are consistent with text and history, even though I think there's reason to be skeptical about that. I think they will duck the bigger questions about whether you can tax as income unrealized gain on stock by your average shareholder. The thing that we're really worried about, which is wealth taxes on the rich who own tons of stock, but may or may not have a controlling interest in such companies. And I think the court will not go to that and may even suggest that that's a bridge too far, but that they don't have to decide that now, that for this, the notion of imputing the income to a domestic shareholder who owns part of a foreign corporation, a substantial part of a foreign corporation, they'll say that's okay and consistent with past precedent and past history, even if you think realization is required. They'll just say it's a virtual or imputed realization in those situations, and that will be enough.
That's great, Erik. In the 1 minute we have left, are there any other cases that we should be watching for, and that you think would have a significant impact on Americans and on the nation?
A few, yes. I'll quickly. SEC versus Schaerr-Jaffe is a case dealing with sort of administrative tribunals. The SEC doing in-house trials. Basically, I think if the SEC loses that, it will have a lot of impact on administrative agencies and how they can sort of basically force people out of the courts and into their sort of captive legal system and impose lots of pain on them. I think U.S. versus Rahimi, which is a Second Amendment case, the particular outcome of that case is not that interesting because Rahimi is a piece of dirt. But I think it's important in terms of how they're going to apply the Bruin analysis in reaching what I think is a situation where it's a very unappealing litigant dealing with the Second Amendment question. I think the bump stock case, Garland versus Cargill, will be important not for bump stock so much as it is for the scope of the rule of lenity, and that impacts people subject to criminal laws all across the country. I think Murphy versus Missouri, which is the sort of government jawboning case, sort of coercing social media sites to ban certain speech, will be very interesting complement to the net choice cases. And we're dealing with the government speech doctrine. It's one thing to say those media platforms have their own choice. It's another thing to say the government could strong arm them. And I think, of course, Trump v. Anderson, which was already decided, was a big case. I actually think the case was decided incorrectly. And I think a lot of the theory behind that case contradicts large swaths of other law, but it was driven mostly by a policymaking analysis of this would be bad for the country. Again, I find that amusing coming from conservative justices, but there you have it.
Well, thank you very much, Erik. I really appreciate that. For all our listeners out there, you can see why we at Pacific Research Institute are so privileged to be able to work with Erik on a number of these cases and to have his expertise. I'll tell you this, Erik, I wish you were my constitutional law professor when I was back in law school. So,
well, thank you very much for the compliment. And I always enjoy coming on this show and talking with you guys, and of course, working with PRI in a lot of these important cases.
Well, thanks very much, Erik. And until next time.
If you like this episode, please tell your friends and subscribe to PRI's podcast at iTunes, Google Play, TuneIn, iHeartRadio, and Spotify. And when you're on these platforms, don't forget to give us a big 5 stars. If you don't subscribe to any of these, you can still listen on PRI's YouTube page, youtube.com/Pacific Research 1. That's the number 1. Thanks for listening. I'm Rowena Ichon. Hope you'll come back again for next round with PRI.